This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under some
Yes.
sort of a pseudo-legal jargon.
I am the living man that has a womb. This court system operates like a bank.
Tierra Butler, we'll go back on the record in 64D01-2306F65582. I have a request for pro se. She would like to represent herself in this matter. So I'd like to conduct a Faretta hearing. Yeah, I have one here, but I'll use this one. That's fine. Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Are you under the influence of any alcohol or drugs today?
No.
All right. Have we set a trial in your case? I was going to get back in the calendar here, get back in the file rather. I closed it.
We did, Your Honor.
Oh, that's right. Yeah, we set a trial already. Your trial set for August 18th and 19th. And you've indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you a whole
a
new
spare. You're just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Oh, go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So for that being said, I'm coming here with honor, clean hands, and no conversing. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Faretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes.
different things like this.
Yes.
And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had ended up
Well, that's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
it should be April 16 or 15.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
it-
pseudo-legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is
Means
the Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brand new violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Faretta hearing.
That's a brandy violation. Brandy violation. Yeah, you're not doing that well. First off, it's a Brady violation. So you're claiming that the prosecutor did something with discovery. Okay, but it's Brady, not Brandy.
I know, but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, man.
Ignored me.
What you have filed through the clerk's office, you're saying are matters in equity. We don't recognize what you're talking about in these filings.
This is a bank. This is a bank. I understand how the.
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever.
Hold on, let me finish.
No. I'm not gonna let you finish that
Okay.
particular statement.
I said, I want to
Because
preface
I
this.
just
Don't
need-
want to argue.
I need
anything.
you to,
I just want you to
redirect-
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes.
You will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes. It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something that, and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
So you're
So you will not
striking
strike it?
Rules.
You won't strike it down or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
how You
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay,
You realize
But-
that?
but let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
What I also want to say something, and also I am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its authorizations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon it and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No,
and attempting to apply commercial law to criminal prosecution,
No.
more equitable law.
no, that's not
Ma'am, you keep
true.
saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.